Ready, start. At the initial stage of framing of a charge, the court is concerned not with proof but with a strong suspicion that the accused has committed an offence, which, if put to trial, could prove him guilty. Full stop. All that the court has to see is that the material on record and the facts would be compatible with the innocence of the accused or not. Full stop. The final test of guilt is not to be applied at that stage. Full stop. Under section 226 of the code, while opening the case for the prosecution, the prosecutor has got to describe the charge against the accused and state by what evidence he proposes to prove the guilt of the accused. Full stop. Thereafter comes the duty of the court to consider the record of the case and the documents submitted therewith and to hear the submissions of the accused and the prosecution in that behalf. Full stop. The judge has to pass thereafter an order either under section 227 or section 228 of the code. Full stop. If double inverted comma, the judge considers that there is no sufficient ground for proceeding against the accused, he shall discharge the accused and record his reasons for so doing, double inverted comma close, as enjoined by section 227. Full stop. If, on the other hand, double inverted comma, the judge is of opinion that there is ground for presuming that the accused has committed an offence which within bracket B bracket close is exclusively triable by the court, he shall frame in writing a charge against the accused, double inverted comma close, as provided in section 228. Full stop. Reading the two provisions together in juxtaposition, as they have got to be, it would be clear that at the beginning and the initial stage of the trial, the truth, veracity and effect of the evidence which the prosecutor proposes to adduce are not to be meticulously judged. Full stop. Nor is any weight to be attached to the probable defense of the accused. Full stop. It is not obligatory for the judge at that stage of the trial to consider in any detail and weigh in a sensitive balance whether the facts, if proved, would be incompatible with the innocence of the accused or not. Full stop. The standard of test and judgment which is to be finally applied before recording a finding regarding the guilt or otherwise of the accused is not exactly to be applied at the stage of deciding the matter under section 227 or section 228 of the code. Full stop. At that stage, the court is not to see whether there is sufficient ground for conviction of the accused or whether the trial is sure to end in his conviction. Full stop. Strong suspicion against the accused, if the matter remains in the region of suspicion, cannot take the place of proof of his guilt at the conclusion of the trial. Full stop. But at the initial stage, if there is a strong suspicion which leads the court to think that there is ground for presuming that accused has committed an offence, then it is not open to the court to say that there is no sufficient ground for proceeding against the accused. Full stop.